Good evening and welcome to Arizona Horizon. I'm Ted Simons. The state Supreme Court is set to hear a case involving Proposition 211, which was passed by voters in 2022. Now, the law requires people and organizations donating to political campaigns to disclose who they are and how much they donated. But opponents of the measure argue that such disclosure violates free speech rights. The State Court of Appeals has already rejected those claims, but the state's highest court has agreed to take up the case. We will hear from those in favor of the law tomorrow night, but tonight, former Arizona Supreme Court Justice Andrew Gould joins us, representing those opposed to Prop 211. Good to see you again. Thanks for joining us.
Thank you, Ted. Good to see you, too.
All right, so this was passed by over 70% of the voters here, Andrew. They passed this thing, and they wanted dark money out of the way. What exactly does the law require in terms of money amounts?
So what it does is it requires disclosure on what are called independent expenditures. These are donations to nonprofits. It's been the law for many, many years. When you give to a candidate directly or give to a candidate committee, your name is disclosed. This now reaches into nonprofits like Center for Arizona Policy, Free Enterprise Club, and requires disclosure not of just donors over $5,000, but actually goes upstream and gets original donors as low as $2,500.
I saw there's a $50,000 limit there on state campaigns and $25,000 on local campaigns?
That's for the organization. It's called the covered person.
Yes.
So once that organization hits $50,000, then these disclosure requirements kick in.
Okay, now the case involves two anonymous donors. Is that what we're seeing here?
Two anonymous donors and then two organizations.
Okay. The appeals court, let's just get right to what the appeals court said.
Sure.
And they're saying that neither of these the complaints, they didn't allege any donor harassment, which is kind of at the crux of your position, is it not?
It is, Ted. Under the Constitution, if you can show retaliation for your donations, then you have what's called an as-applied challenge. You can get an exemption from that law. I don't think it takes any great knowledge to understand the acrimony in today's politics. So when you force disclosure, as this law does, of people's employment, their home address, their names, they face retaliation. I disagree with the Court of Appeals. The record was replete with death threats and vandalism. It was so bad at Capps Building they had to hire private security. So for whatever reason, the court wasn't convinced by that. I think if you compare the threats and the retaliation and harassment that occurred here, it more than meets the standard.
The court said that there was no evidence of harassment and there was no evidence of a chilling effect. How do you square that?
Well, I disagree. There were affidavits, there was testimony, deposition testimony from witnesses who said they received death threats, they received recordings, there was damage to the buildings. It's just not square, doesn't square with the record. Some of what the Court of Appeals said was, well, this is just political speech. Well, that may be, but whether it's political speech, you can't retaliate against people and threaten them under the Constitution.
The two anonymous donors, did they experience harassment? Did they experience retaliation?
No, but there's a fundamental point here to be made. When you threaten an organization, you chill other members of that organization. Think of it this way. If you were someone who contributed to an organization and you found out that another member had a Molotov cocktail thrown through their window because they were a member of that organization, that would probably discourage you from giving to that organization. And that's what the law says. That's what the United States Supreme Court says. If you chill speech by threatening the organization or any of its members, then that's retaliation.
And again, that would go against the ruling in which the judge basically said no evidence that the suits with the states, it coincides with the state, I think the quote is, interest in having an informed electorate. How can you have an informed electorate if we don't know where the money's coming from?
Well, the disclosure rules in terms of campaign finance are typically based on what's called an anti-corruption interest. In other words, one person giving too much money to a candidate, the concern is that the candidate, when they get in office, will be controlled. The informational interest is very broad, but here's the problem with the informational interest under this statute, Ted. The statute is written so broadly, it sweeps in everyone who gives to these nonprofits, people who just give for issue advocacy, or people who want to contribute money to develop policy. It traces back anything that is in any way related or in preparation for some of this campaign media spending. No one understands where to draw the line. It's impossible.
Judge Silver also said that there's a strong governmental interest in knowing who is funding campaign media spending. There's a strong governmental interest. Got a point there?
Well, there is, but where do you draw the line? People may want to know things that, what's the race, what's the sex, what organizations does a person belong to? Those might help somebody decide about who's contributing, but we don't allow that. So the connection between somebody giving to a nonprofit just to engage in some issue advocacy and things they believe in and disclosing their names, it's a very tangential interest, and the law requires that relationship to be very substantial and tight. Here, it covers virtually any donation to a nonprofit.
Now, correct me if I'm wrong. Did the founders not require disclosure of campaign state founders? Wasn't that in the original Constitution?
Only for campaigns and candidates.
Yes.
It's Article 7, Section 16, very specific. It does not include ballot initiatives like this law does, or independent expenditures. Specifically doesn't include
Do you think it was intended to not include those things, or were those things not as big a factor as they are now?
I do, because at the time there was an alternative proposition that was offered. It was called Proposition 70. And in that, it was a much more expansive law. It covered all contributions to influence any election. And the founders rejected that in 1912 and chose a much more narrow provision. So by rejecting it, and picking a more limited provision, I think that's what they meant to do.
For those who would agree with you that, if a Molotov cocktail goes through someone's window because they donate to XYZ, then maybe someone else may not want to donate to XYZ. The trial court said that there is no right to hide, a right to hide for campaign contributions. What do you make of that?
Well, I don't know what the right to hide means. What I do know is that there is a constitutional right to anonymous political speech. The Federalist Papers were all anonymous. In 1912, when the initiative for women's suffrage was on the ballot, all the contributions to that initiative were anonymous. When the Anti-Saloon League wanted to put prohibition on the ballot, all of the contributions to that initiative were anonymous. We have a long history of anonymous speech, and I would go further, Ted, and say that's part of why reason why we adopted a secret ballot is so people can vote anonymously, not face retaliation.
But in terms of influencing elections, why should people be able to influence elections in secret?
Well, we influence elections in many ways. Some of it is through contributions, some of it is through anonymous papers, but people have a right to be able to engage in expressive association with groups they support, and there's a right to avoid retaliation. In this day and age, if you support one party or another, one cause or another, you face doxing, social ostracism, you face destruction and violence. Now more than ever, there has to be some vehicle for people to be able to contribute anonymously.
And again, we're going to get the other side on tomorrow, but I would think the other side would say something along the lines of, well, let's the appeals court decision. Without disclosure, I'm going to read this verbatim here, the public could never evaluate the true source of the funds hidden by filtering through front groups or intermediaries.
Mm-hmm. We have a long tradition that allows people to give to nonprofits without having their names disclosed. If you want to strip that away, we'll lessen the amount of speech in this country. The idea that we want full and robust discussion on political issues, that's what we want in this country. Doxing people and disclosing their names only silences people.
But the full and robust discussion should not necessarily include who is sponsoring the full and robust discussion.
That's right.
All right. Andrew Gould, thank you so much for joining us. It's good to see you again. Thank you.
Good to see you. My pleasure.